We are now in Lecture 1, Part 5 on David Ingram's Law. Here we're going to discuss criticisms of positivism and the positivist rule of law. We're going to examine three thinkers: Raz, Fuller, and Finnis. We're also going to look at the moral values that emerge from that as the core of law and the rule of law. And these two core moral values are going to be one, regard for equality, two, rationality of human beings. We're going to look at the minimalist positive as well as the expanded natural law versions of this moral core of law based on those two moral values: regard for equality and rationality of human beings. Ingram argues that a major problem with positivism is its failure to explain how we are not merely coerced by rule of law, but that we follow it of our own volition, and not simply as a necessary evil of limiting our desires in order to prevent an even greater evil of anarchy, in which even fewer of our desires would be fulfilled. But we must go deeper into the natural law theory, positivism, and the rule of law itself in order to present the moral core of the law more clearly. Let us now bring up a few more thinkers from the more contemporary philosophy of law. Two who are natural law theorists, Finnis and Fuller, and one who is a positivist, Raz. We start with Raz. According to Raz, the rule of law, which is absence of arbitrary coercion, that we'd already gotten from our thinking about Hobbes. So the rule of law, according to Raz, on a very thin conception of it that emerges from the positivist tradition, can be instrumental and compatible with laws or legal systems that do not aim to bring about justice or the common good. Slaveholding societies can be said to have rule of law on this conception. So could Nazi Reich, right? Coercion is not coercion and is not arbitrary so long as it is written into the rule of law, goes Raz. And if that maintains peace and order, all right, that's one way of maintaining peace and order, according to Raz. Instrumental conception of law here means that law is not in itself thought to be just or unjust, but only useful insofar as it brings about a certain desirable result. For a positivist, the law in itself is neither just or unjust, but only insofar as it promotes peace or stability. In other words, law is not just or unjust in any kind of a deep sense, but it may be just in the sense that it promotes peace or stability, or unjust in the sense that it destroys peace or stability. That's the instrumental conception of law. Next thinker, Fuller, a natural law theorist, points out that, in a sense, morality is already operating, even in the instrumental positivist conception of the law. Even the instrumental positivist conception of the law, insofar as it contains the rule of law, even in the minimalist Hobbesian and Razian sense, of preventing governments and groups in power from harming individuals and establishing peace, order, and stability, harming order, peace, order, and stability. So even that minimal conception of the rule of law presupposes regard for each person's equality with others, as well as for their rationality. Regard for each person's equality and rationality are moral values, and to that extent, and are a necessary core of law, even on the positivist instrumentalist conception. Without them, society would turn into anarchy and conflict. Fuller calls their necessary presence in the rule of law as the core of the rule of law, the inner morality of law. Still, Fuller argues that this conception of rule of law is too thin and contains only some portion of the bare minimum of morality, and that a much thicker notion of the rule of law as well as of morality is needed. After all, in a certain sense, rationality and equality of slave and master can be said to be preserved minimally when both master and slave are informed about their respective rights and responsibilities to establish a stable society of a particular kind, obviously. By being informed, their rationality is given regard, and equality is given regard by that they are both informed. But this arrangement cannot be morally just. We probably mean much more than this by the moral core of law that regards equality and rationality of all human beings. We only get the bare minimum of it in the inner morality of law on the positivist version. A more expanded notion of the rule of law comes from another natural law theorist, Finis. Finis nicely sums up the positivist tradition and goes beyond it by claiming that there are two functions of the rule of law. One, to protect individual freedom from their arbitrary government power. Two, to promote justice and the public common good. Here are the four conditions of rule of law according to Finis. This is the expanded notion of the rule of law, expanded beyond that of Raz. Right? Finis is a natural law theorist. Raz was a positivist. Here are the four conditions of the rule of law according to Finis. Condition one, law cannot advance interests of some in opposition to everyone else. That's the common good thesis. Condition two, law cannot usurp rightful authority of another. Say that of the executive or the judicial branch. Condition three, law cannot make laws while denying dignity of self-direction. This is the necessity of participation in lawmaking, democratic participation, it must seem. Condition four, law cannot result in unequal treatment or denial of laws to all. Keeping in mind Fuller's objection to Raz, we can understand Fuller's definition of law as embodying the moral values of regard for rationality and equality, but on a necessarily much more expanded understanding of rationality and equality that a positivist would have to endorse. Laws that justify slavery can be acceptable on Raw's account, but would be unacceptable on Finis's account. They privilege the interest of slaveholders over that of slaves, do not allow slaves to vote, etc. So, in other words, they would not fulfill the four conditions of the rule of law on a thicker interpretation of the rule of law that Finis presents to us.